The address you gave, sir, is that a residence or place of business or both? It is a residence. It is my house. How long have you resided there? Defendant's counsel. Objection. Palpably irrelevant. I was not under an obligation to permit inquiry into his personal address because it's K&J, a company that's being sued. I am not going to permit any unwarranted intrusion into my witness's personal life. Plaintiff's counsel, are you directing the witness not to answer, sir? Yes, I am. I am directing him not to answer, Your Honor. The court. Objection overruled. That's palpably irrelevant, and I don't think you have a right to that information. Are you currently employed, Mr. Powers? Yes. By whom? Malloy Restoration. Is that the full name of the business, or is it not? Yes, it is. And will you tell us, please, the representative who is impleaded, that is, Arrow Restoration, and our office had impleaded your company, I believe, into this lawsuit. Is that correct? I am going to be asking some other points this morning about the circumstances surrounding this suit and you or your company involvement in it. If any time you don't understand a question, please say so, and I will rephrase it, so hopefully, eventually, we come to some meeting of the minds. Tell me this, the address you gave, sir, is that a residence or a place of business? It is a place of business. It is a commercial establishment. It is not a residence. Tell me this, sir, with respect to the residence, do you say that you lived there for some period of time? Yes, I do. And with respect to that period of time, to begin with, the defense has not told us what such a warrant would entail and what was asked. So could you offer no suggestion as to naming the crime involved or, as required by the Fourth Amendment, the things to be seized? And that is the one problem, the core problem with defendant's position. Before entering the apartment, the police encountered evidence, that is, no evidence of any crime, and the circumstances and do lend themselves to criminal processes. The police were not functioning in a criminal arena, but acting as public agents in the name of protecting public health and safety. They proceeded with restraint and took the time to deliberate, using only that evidence after exhausting other reasonable avenues. Secondly, we are not impressed by defendant's suggestion, implicit in the argument, that the entry would be substantially under the emergency exception only if the police broke in immediately. Defining an emergency with the rigidity defendant proposes may encourage the police so as to give them their actions, that is, the appearance of an emergency, to break in prematurely before exhausting other reasonable means of gaining access. It would be an ironic result were we to punish the constabulary by suppressing the evidence merely because they took the time to exercise some safe judgment. Here, in addition to the harassment violation, defendant was mildly charged or initially charged with criminal contempt in the second degree, a misdemeanor punishable by up to a year in jail. See Penal Law, Section 70.15. It requires that the people be ready for trial within 90 days of the commencement of criminal action wherein a defendant is accused of one or more offenses, at least one of which is a misdemeanor punishable by a sentence of imprisonment of more than 3 months, and none of which is a felony. Accordingly, at the time this action was commenced, the applicable speedy trial period was 90 days from the filing of the accusatory instrument. When it dismissed the misdemeanor 9 months later, City Court retroactively reduced the 90-day period and applied a 90-day period in the remaining time period of the charge.